FishFAQ.
A patent is a temporary grant of an exclusive right, the right to prohibit others from practicing a claimed invention. For a long time, those in charge of society have recognized that inventions, which are solutions to existing problems, can be a benefit to everyone. As such, they should encourage inventors to invent by protecting their ideas from infringers. As far back as ancient Greece, we find evidence of intellectual property rights being granted, where encouragement was held out to all who should discover any new refinement and luxury, the profits from which were secured to the inventor for a space of a year. In the Middle Ages, the English crown was granting letters patent, from the Latin litterae patentes, or open letters, to inventors who petitioned and were approved. The open letter was a public declaration of the rights granted. The earliest authenticated instance was a grant given to John Kemp in 1331. By 1450, Venice was systematically granting patents. Unfortunately, the patent system has at times been abused as a money-raising mechanism by the government, who would grant monopoly rights over all kinds of known industries. In response, the courts began to limit granting monopolies only on inventions. In particular, the English courts continued to refine the patent system through the years, and during the reign of Queen Anne, patent applicants were required to supply a complete set of principles of operation of the invention for public access. Towards the end of the 18th century, the granting of patent rights came to be viewed as an intellectual property right, as opposed to an economic privilege obtained through payment. Protection of intellectual property is enshrined in the U.S. Constitution at Article 1, Section 8, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This has been interpreted as providing the federal government with control over patents and copyrights, with the U.S. Patent Office opening its doors in 1790. Currently, the patent systems in the U.S. and other countries are designed to promote a climate of innovation. In exchange for a temporary monopoly, inventors are required to disclose their inventions in sufficient detail to allow others to practice the claimed technologies. The concept is that without the monopoly, most inventors would do their best to keep the details of their inventions to themselves as trade secrets. There are differences from country to country, with, for example, some countries refusing to issue patents on treatment of humans. But in general, encouraging invention remains the goal of the various patent systems around the globe. Thanks for watching. Fish IP Law.
FishFAQ.